On August 15, 2002, a drug enforcement agency-led SWAT team raided the home of Angel Raish. The members of law enforcement destroyed marijuana plants, which were illegal drugs under federal law, but legal medicinal plants under California law.
Miss Angel Raish, I am Agent Osborne with the DEA. I am here because I have a warrant for your arrest, ma'am.
No,
Ma'am,
you can't do this.
Yes, ma'am, I am so sorry. If you would please stand up. Ma'am, I understand that.
I have a brain tumor.
And I understand, ma'am, and that is so
This is for my pain.
Yes, ma'am,
when I have this,
ma'am, I can't argue with you. This is a time-sensitive matter. We have to go. If you would please stand up and place your hands behind your back.
Please don't hurt me.
No, ma'am, I would
Please
never
don't hurt
you.
me.
No, ma'am, I would not. If you would place your hands behind your back, are you able to do so?
Yes.
Angel Raish, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to have an attorney present. If you cannot afford an attorney, one will be appointed to you at no cost to you.
Attorney General Alberto Gonzales gave Solicitor General Paul Clement the difficult task of arguing the federal government's case before the Supreme Court.
Hi, Paul. How you doing?
Good afternoon.
How you doing this morning?
I am doing good, sir. Thank you.
Awesome, great. We have this case that is going to be argued in front of the Supreme Court, and I want you to handle it. It's a case on medical marijuana in California, so please give it a look and let me know.
That is such a great honor to be able to argue this case. Sir, thank you.
Absolutely. Good luck.
Thank you, sir.
Speaking on behalf of the United States, Clement argued that under the Controlled Substances Act, Congress had comprehensively regulated the national market in drugs with the potential for abuse.
Justice Stevens, and may it please the court. Through the Controlled Substance Act, Congress has comprehensively regulated the national market in drugs with the potential for abuse.
With respect to Schedule I substances, like marijuana, that have both a high potential for abuse and no currently accepted medical use and treatment, Congress categorically prohibits interstate trafficking outside the narrow and carefully controlled confines of federally approved research programs. Clement also argued that the federal government had the right to regulate marijuana under the Interstate Commerce Clause of the United States Constitution. Justice Sandra Day O'Connor pressed Clement on the commerce issue, pointing out that under California law, no medical use marijuana produced in California would ever be exported out of California, and that commerce within states is the area of something traditionally regulated by states.
As I understand it, if California's law applies, then none of this homegrown for medical use marijuana will be on any interstate market. And it is in the area of something traditionally regulated by states.
Justice O'Connor asked Clement how the federal government could justify regulating marijuana if it was not a component of interstate commerce. Clement replied that there was no reason to assume that California's government could possibly keep marijuana grown in California from being sold outside the state.
Well, Justice O'Connor, let me first say that I think it might be a bit optimistic to think that none of the marijuana that's produced consistent with California law would be diverted into the national market for marijuana.
Well,
into
but
the national
in
market.
Looking at this broad challenge, do we have to assume that the state of California will enforce its law? I mean, if it turns out that it isn't and that
think that there's any reason to assume that California is going to have some sort of almost unnatural ability to keep one part of a fungible national drug market separate.
Speaking on behalf of Angel Raish, Randy Barnett addressed the court.
I have 2 points to make. First, the class activities involved here, in this case, are non-economic and wholly intrastate. Second, the federal prohibition of this class of activities is not essential. It is not an essential part of the larger regulatory scheme.
Barnett argued that medical marijuana produced in California was only for use in California, that it was medical and not economic activity, and that since it was not commercial activity, the federal government had no right to regulate it under the Interstate Commerce Clause of the United States Constitution. Barnett warned the court that if the court allowed the federal government to prohibit the use of medical marijuana in California, they would vastly expand the power of the federal government to regulate commerce within states. A horrific power grab that would deprive states of their rightful authority to regulate commerce within their borders. Justice David Souter pressed Barnett on this issue and asked him what would prevent medical marijuana in California from spilling over into the black market in other states.
But I don't see what reason that you have given, or any reason that you haven't given, for us to believe that out of, and I'm going to assume for the sake of argument, 100,000 potential users, everybody is going to get it from a friend or from plants in the backyard. Seems to me the sensible assumption is they're going to get it on the street. And once they get it, under California law, it's not a crime for them to have it and use it. But they're going to get it in the street. Why isn't that the sensible assumption here?
Well, they have a very strong incentive not to get it on the street, because getting it on the street is going to subject them to criminal prosecution under both California and federal law.
But it's also the case that approximately 10% of the American population is doing that every day, if I accept the figures in the government's brief, and they're not getting prosecuted.
In response, Barnett emphasized that this was a program for sick people in desperate need of medical care, and that these sick people had a very strong incentive to keep their medicine for themselves.
In that case, we're talking about people who are using it for sport, for recreation. We are talking about a class of people here who are sick people.
He argued that these sick patients would not trade their life-saving medication for the few dollars they might earn for selling a product which was already widely available for very low prices on the black market.
Cannabis does have a substantial medical effect. Smoked cannabis does carry with it harms associated with it, as General Clement correctly pointed out. It does carry with it these ancillary harms, but when people are sick and people are suffering and people are dying, they may be willing to run the risk of these long-term harms in order to get the immediate relief, the life-saving relief that cannabis has demonstrably been able to provide.
In a 6-3 opinion delivered by Justice John Paul Stevens, the court held that the Commerce Clause gave Congress the authority to prohibit the local cultivation and use of marijuana despite state law to the contrary. Stevens argued that the court's precedent firmly established Congress's Commerce Clause power to regulate purely local activities that are part of a class of activities with a substantial effect on interstate commerce. The majority argued that Congress could ban local marijuana because it was a class of activities that impacted interstate commerce, since there was no way to guarantee that medical marijuana in California would not be exported to other states. Since the Supreme Court declared California's medical marijuana law illegal in 2004, several other states have passed similar legislation in direct violation of the court's findings. The medical marijuana controversy is far from over, and leading experts continue to debate the medical value and the legalities of medical marijuana.
One of the biggest harms is the addiction. Having served 18 years in law enforcement, I dealt with individuals that at one time were just marijuana smokers. Once you no longer have that high, you're gonna search for something bigger. They just wanted that higher fix that they were no longer getting from marijuana. Some folks move from marijuana to pills that either are not prescribed to them or pills that they cannot afford, which now throws them into criminality. Taking from others, selling what is not yours. Those are some of the harms of marijuana usage.
As regards the medical use of marijuana, there is a component or drug that is available. Marijuana is a mind-altering psychoactive drug, and tetrahydrocannabinol, also known as THC, is believed to be the main psychoactive component that produces this effect. Personal experience in my patients, people who had refractory nausea and vomiting, they benefited immensely when every other drug that we utilized failed. When used appropriately and under appropriate guidance, this drug has many beneficial uses. It has incredibly good use, especially in the setting of chronic pain, difficult to deal with nausea and vomiting in patients, and also for its appetite stimulating effect in people who have terminal cancer, for example.